Hi everyone, welcome to SQE1 window, and we start our chapter 5 in our criminal litigation. So we are stepping up to Crown Court from Magistrate Court. So we will examine how cases are prepared for trial and how trials actually run before a judge and jury. The chapter represents a significant shift from Magistrate Court practice like that we have already discussed. So what changes here? So let's identify what fundamentally changes when we move from Magistrate Court to Crown Court. The Crown Court tries indictable only offences. So the most serious crimes like murder, rape and robbery. It also tries some either way offences where the case has been allocated to Crown Court or where the defendant has elected jury trial. So here is the critical structural difference. Roles are divided between judge and jury. The judge decides all matters of law and procedure, what evidence is admissible, how the law should be applied, and procedural questions. The jury decides all matters of fact. So what happened, who is telling the truth, and ultimately whether the defendant is guilty or not. So the complexity is higher. Cases involve more evidence, more witnesses, and more sophisticated legal arguments. Trials typically last days or weeks rather than hours. So the stakes are higher too. So sentencing powers in Crown Court are significantly greater than in Magistrate Court. For many offences, the Crown Court can impose life imprisonment, whereas magistrates are typically limited to 6 to 12 months. So in exam, they can ask who decides law versus fact. Judges decide law, jury decides fact. So never confuse these two things. So modern Crown Court practice operates through the digital case system, DCS, and better case management, BCM. Let's understand what these systems achieve. The indictment and all case papers are uploaded to DCS. This creates a shared digital bundle accessible to all parties like prosecution, defense, and the court. Everyone works from the same material. So evidence access is immediate and simultaneous. Gone are the days for waiting for physical bundles to be copied and delivered. Digital access means efficiency and transparency. So BCM tightens timetable and directions. The court takes an active case management role, so setting firm deadlines and holding parties accountable. This reduces adjournment and delays that historically plunged Crown Court trials. So the combination of DCS and BCM fundamentally changes Crown Court practice, making it faster and more efficient whilst maintaining fairness. In exam, they can ask you DCS. Most of the time they won't, but you need to just keep in mind they might. So let's shift to defense counsel's perspective. What are the early core tasks when you receive a Crown Court case? First, interview your client fully. You need comprehensive instructions about the alleged offense, their account of events, their background, and any relevant personal circumstances. This interview should be detailed and, it should cover all aspects and no rush interview. So, second, draft a proof of evidence capturing everything your client tells you. This privileged document becomes your case roadmap, constantly updated as information emerges through trial. So third, obtain the police interview record, the recording or transcript of your client's interview under caution. This is crucial because it shows what your client said to police and forms part of the prosecution case. So fourth, obtain the custody record. The documents what happened during detention, when reviews occurred, whether rights were explained, condition of detention, and everything was not breached at that point. So custody record gap can reveal pace breaches, and that can be your strength in that case. Fifth, request your client criminal record. You need to know their previous convictions because affect bail, potentially affect admissibility of evidence, and are relevant to sentencing if convicted. So in exam, they can ask what must you obtain before advising at that point. So at minimum, proof of evidence, police interview, custody record, and criminal record. So that's what is your points that you need to keep in mind. So defense inquiries beyond the court tasks, proactive defense inquiries can strengthen your case significantly. First, interview defense witnesses early, so memories fade at that point. So take witness statement whilst recollection are fresh. They can just recollect all those thoughts. So these witnesses might support your client's account or undermine prosecution witnesses. Second, visit a scene where it matters, like you need to visit it if it is required. Photographs and plans don't capture everything. Personal observation reveal all nitty-gritties, distances, lighting, and other circumstances around the scene. You can understand it more once you visit it. Third, identify CCTV and digital evidence. Many locations have cameras, traffic cameras, shop cameras, residential doorbells. Cameras might capture relevant event. Identify and preserve this evidence before it is deleted. Fourth, consider expert evidence promptly. Does the case involve forensic issues, medical questions, or technical matters requiring expert opinion? Instruct experts early. Their reports take time and might fundamentally change case strategy. So fifth, preserve your defense case theory. So as you gather information, you are building a coherent narrative that challenges the prosecution case. So each inquiry should test and refine this theory. So in exam, they can ask which inquiry changes case theory quickest. Once it's expert evidence or scene visit that reveals prosecution weakness not apparent from paper alone at that point. So now let's jump into first appearance. So even for indictable only offenses that will go to Crown Court, the defendant first appear in magistrate's court. So let's understand why and what happens there. The defendant appears before magistrates who conduct an initial hearing. The defendant indicates whether they would plead guilty or not. This indication matters because guilty pleas receive discount even in the Crown Court. So issues are identified for Crown Court to address later. The magistrates don't try the case, they simply process it for sending. So crucially, a bail decision must be made. Will the defendant be remanded in custody or released on bail? The decision profoundly affects case preparation and the defendant's life. So the case is then sent to Crown Court under Section 51 of Crime and Disorder Act 1998. Sending is automatic for indictable only offences. So in exam, they can ask, why does an indictable case begin in magistrate court? So because statute requires it, that's number one. The initial hearing handles administrative matters efficiently before the case reaches to Crown Court at that point. So it's a filter, statutory filter you can call it. So the next thing is, after sending, Crown Prosecution Service must serve prosecution trial material within strict deadline. So these deadlines depend on the defendant's custody status. If the defendant is remanded in custody, the CPS has 50 days to serve. If the defendant is on bail, they have 70 days. These are firm deadlines. Breaches create serious consequences. So what's included in the case sent bundle? First, draft indictment, the formal charging document for Crown Court. Second, all used material, evidence the prosecution intends to rely on at trial at that point. So this includes witness statements, exhibits, forensic reports, and digital evidence. Third, a schedule of unused material with initial disclosure under CPIA Section 3. This identifies material the prosecution holds but is not using, disclosing anything that might undermine their case or assist the defense. So in exam, they can ask, state the 50-70 day rule, and you need to keep in mind that 50 days if in custody, 70 days if on bail. So that's what is rule of thumb, and you need to memorize it. You need to just keep this in mind. So the unused material schedule deserves particular attention because disclosed issues frequently arise here. The prosecution must disclose material that might reasonably be considered capable of undermining the prosecution case or assisting defense case. This is the CPIA test, and it's applied to everything the prosecution holds. So unused material covers items not included in the used evidence, witness statements not being called, alternative CCTV angles, telephone records, social media content, medical records, and much more. So CCTV commonly arises in disclosure disputes. Perhaps the prosecution uses one camera angle, but other camera captured different perspectives. So the defense might request those additional angles as well, like at that point. So the defense should make targeted disclosure requests when they believe the relevant material exists but has not been disclosed. Be specific, identify what you are seeking and why it meets the test. So the prosecution must keep disclosure under continuous review. As the case develops, material that previously did not meet the test might become disclosable. So in exam, they can ask, what is the unused disclosure test? So material that might reasonably undermine the prosecution case or assist the defense. So that's what we need to understand from this slide. So another thing we got, and that's very critical point, many of us we miss, disclosure is not one-time event. Under CPIA section 7A, there is a continuing duty that runs throughout the case. The prosecutor must keep disclosure under constant review. A new material comes to light, or as the case develops, they must consider whether disclosure obligation changes or not. So this duty continues until the case concludes through trial, verdict, an appeal if relevant. So it does not stop after initial disclosure or after the defense statement. So late material that meets the disclosure test must still be disclosed. Even on the eve of trial, the continuing duty is absolute. So the defense can challenge non-compliance through case management applications. So the court has power to enforce disclosure obligation and can impose sanction for breaches. So in exam, they can ask, when does the duty to review disclosure ends? Only when the case finally concludes. Until then, the prosecutor must continuously review and disclose whatsoever they need to disclose under law. So the defense has a disclosure obligation too, though they are different from prosecution duties. If defense intends to call witness at trial, they must notify the prosecution and court. The deadline is 28 days after receiving prosecution disclosure. This witness notice requirement ensures the prosecution knows which witness to expect and can investigate their credibility or background if necessary. It prevents trial ambush, so avoid late witness problems by meeting this deadline at that point. That's 28 days deadline and you need to meet it. So late notification might result in witness being excluded or the trial being adjourned, neither of which helps your client. So align witness notification with court directions. The PTPH will set specific timetables and compliance is mandatory. So if witness plans change, record your reason, the court need to understand why witnesses are added or withdrawn after initial notification. So in exam, they can ask, what must the defense notify within 28 days? So that's what you need to keep in mind. So next thing is mandatory defense statement, what it must include. In the Crown Court, unlike magistrate court, serving a defense statement is mandatory. So let's identify what it must contain. First, the nature of the defense in general terms. What's your case theory is. So self-defense, alibi, mistaken identity. The jury will hear this or articulate it. So you need to articulate it in a clear fashion. So, second, the specific defenses relied on. If claiming self-defense, say so. If relying on lack of intent, specify that. Third, any facts disputed by the defense and the reason for disputing them. Don't just say, we dispute this. Explain why. If perhaps the witness could not have seen what they claim, or the timing is impossible. So fourth, any particular fact the defense relies upon. These are your positive assertions, what you say actually happened. So fifth, any point of law or admissibility challenges you are raising, flag issues about confession, admissibility, hearsay, or bad character evidence. Six, if relying on alibi, provide full details where the defendant was, when, and which witness supports the alibi. In exam, they can ask, name 3 defense statement requirements. From the list above, you should be able to identify at least 3 among them. So the next thing is case management before plea and trial preparation hearing, that is PTPH. So you complete the case management questionnaire early. This document identifies issues, estimates time, and proposes directions. Take it seriously. It shapes the PTPH. So identify disputed issues clearly. What's actually in contest? Narrow the battleground to what genuinely matters. So agree evidence where possible. Can certain facts be formally admitted? Can witness statements be agreed and read rather than called? At that point, this saves time and cost. Flag matters requiring special attention, expert evidence, hearsay applications, bad character evidence. So legal arguments as well. The court needs advance warning to allocate proper time. So make the PTPH an effective hearing. So if you have done proper case management beforehand, the PTPH becomes efficient and productive rather than a wasted court appearance. So in exam, they can ask what should be resolved before PTPH. Issues identification, evidence agreement, expert flagging, and time estimate. So the plea and trial preparation hearing is the Crown Court's first substantive hearing. Let's talk about it. So first, the defendant is arraigned. This means the indictment is read loud. And the defendant enters a formal plea to each count, guilty or non-guilty to each charge. If the defendant pleads guilty to all counts, the court proceeds to sentencing, often on the same day if a pre-sentence report is not needed. If the defendant pleads not guilty to any count, the case is listed for trial. The trial date is fixed, typically several months ahead to allow preparation. The court then gives comprehensive direction, creating a timetable. When must further evidence be served? When are bad character or hearsay application due? When must the defense statement be filed at that point? So every step is scheduled. So these directions are orders, not suggestions. Failure to comply has consequences, sanctions, wasted cost orders, or adverse inferences at trial. So in exam, they can ask what happens after a non-guilty plea at the PTPH. So that's a trial date is fixed and detailed directions are given setting out the timetable to trial. So let's talk about custody time limits. Those are tested quite often. So for defendant remanded in custody, custody timeline impose strict deadlines on when trial must commence because it is matter of liberty. The standard time is 182 days from when the defendant was sent to Crown Court. That's approximately 6 months. If this time expires without trial commencing, defendant must be granted bail unless the prosecution successfully applies to extend the time limit. So prosecution may seek extensions, but they must demonstrate good reason. Typically, that delay is attributable to the defense or due to unavoidable circumstances beyond prosecution control. So the defense can oppose extension application, arguing the prosecution has caused delay or has not acted diligently. So timetabling becomes central strategy when your client is in custody. Every adjournment, every delay works towards that 182-day limit. So in exam, they can ask, what is the key custody timeline in Crown Court? 182 days from sending the accused to the Crown Court. So the next thing is pre-trial ruling and trial readiness. So as trial approaches, various preparatory steps ensure readiness and efficiency. The judge can make binding pre-trial rulings on legal issues. Common subjects include confession admissibility, hearsay applications, and bad character evidence. Resolving these before trial prevents jury time being wasted. A voir dire trial within trial might be held to determine whether a confession was obtained properly under pace or whether other evidence is admissible. So use witness summons if needed. If a witness is reluctant or might not attend voluntarily, obtain a summons compelling attendance. Agree the record of a taped interview, so that is ROTI transcript, where possible. If both sides accept the transcript accuracy, the jury can read it rather than listening to hours of audio recording. This saves significant trial time. So finally, remember the indictment counts frame the verdict, like at that point. The jury can only convict on counts included in the indictment. So ensure the indictment properly reflects the prosecution case. So in exam, they can ask, why decide admissibility before a trial? So to avoid, of course, wasting jury time on evidence that might be excluded and to allow proper trial, and time management. So let's map the trial flow simply so we understand the sequence. After a non-guilty plea, the jury is impaneled. 12 jurors are selected and sworn. They become the fact finders, like you have watched a movie, 12 Angry Men. So the prosecution opens their case, outlining what they intend to prove. Then prosecution witnesses give evidence, each examined, cross-examined, and potentially re-examined. After the prosecution case closes, the defense may take a half-time submission, arguing there is no case to answer. We shall explore it shortly. If the submission fails or is not made, the defense presents its case. The defense may testify, defense witnesses give evidence, and the defense makes a closing speech. The judge then sums up, and directing the jury on law and reviewing the evidence. So once again, I would say the judge then sums up, directing the jury on law and reviewing the evidence. The jury retires to deliberate and reaches a verdict. In exam, they can ask, where does no case to answer fit in the trial? Same as we did in magistrate court case trial thing. We have done it. We have discussed it early. So courtroom etiquette, Crown Court formality requires proper forms of address. Getting this right demonstrates professionalism and good marks. So when addressing a circuit judge or recorder, use your honor. This is the standard form for most Crown Court judges. When addressing a High Court judge sitting in the Crown Court, use my lord, milady, depending on gender. When referring to a barrister opponent, call them my learned friends or friend. This recognizes their professional qualification and status. When referring to a solicitor opponent, simply use my friend without learned. When addressing witnesses, use formal title, Mr. Smith, Miss Johns, Dr. Patel. So avoid first names unless the witness is a child at that point. In exam, they can ask you a question: how do you address a circuit judge? Of course, that's your honor. So evidence, witness, and questioning. First, competence. Witnesses must understand the question put to them and be able to give comprehensible answers. Most adults are competent, but children are vulnerable witnesses, and that requires special assessment. So examination in chief is when your own witness gives evidence. Crucially, you cannot ask leading questions that suggest the answer. You must ask open questions, allowing the witness to tell their story. What did you see? Not, did you see the defendant hit the victim? Not at all. So cross-examination is when you question the opponent's witness. Here, leading questions are permitted and indeed expected. You are testing their evidence, challenging credibility, and highlighting inconsistencies. You couldn't actually see the defendant from where you stood, could you? At that point, these kind of, and answer is yes or no. So re-examination occurs after cross-examination. You can ask questions to clarify or repair damage from cross-examination, but you cannot introduce new topics. It's limited to matters arising from cross-examination. So other evidence types include hearsay, exhibits, and recordings. Each has special admissibility rules, and we have covered these in other chapters. We will look at them. So in exam, they can ask you when are leading question allowed and when they are not. During cross-examination, yes, but examination in chief, no. So the half-time submission is a critical defense opportunity. This submission is made after the prosecution closes its case. The judge hears it without the jury present. They are sent out whilst counsel argues the legal points. So submission argues there is no case to answer on one or more counts. This might be because there is no evidence on an essential element, perhaps no evidence linking the defendant to crime, or because the evidence is so weak that no reasonable jury properly directed could safely convict the accused. So the judge decides this as matter of law. If the submission succeeds, the judge directs the jury to acquit. The case does not proceed further. If submission fails, the trial continues with the defense case. The defense has lost nothing but making the submission. It's a cost-free opportunity as well, at that point. So in exam, they can state the state half-time submission, how you understand it, how you can explain it, what are the consequences, the cost, and all these other aspects. So the next thing that we got is defense case. So let's complete the trial journey through the verdict. After the prosecution case, the defense may make an opening speech before calling evidence. This is not always done, but can help frame the defense case for the jury. The defendant may choose to testify or may remain silent. This is a fundamental right. No defendant must give evidence. However, remaining silent has consequences. If the defendant stays silent without good reason, the jury may draw adverse inferences under Section 35 of Criminal Justice and Public Order Act 1994. The judge will direct them that they may not must draw such inferences. So it is their discretion. They may. After all evidence concludes, both sides make closing speeches. The judge sums up, directing the jury on law and reviewing the evidence. The judge must be balanced at that point, and he must be fair and not suggest what verdict the jury should reach. So judge don't need to influence jury at that point. So jury retires to deliberate. Initially, they are directed to reach a unanimous verdict, all 12 judges or juror agreeing. If after at least 2 hours they cannot reach unanimity, the judge may accept a majority verdict, 11-1 or 10-2. In exam, they can ask what triggers inferences from silence. At that point, you need to understand it is a discretion. It is not a must. So here we reach to our favorite slide. So first, understand the 50-70 day case send deadline. Calculate from sending date. Adjusted for custody status. Missing these deadlines has serious consequences. Second, remember, defense statements are compulsory in Crown Court. Unlike magistrate court where they are optional, this appears frequently in exam. So third, track the CPIA continuing duty until verdict. Disclosure does not stop after initial disclosure. It is ongoing throughout trial. Fourth, treat PTPH as decisive. The directions given that create the timetable to trial. So missing PTPH deadlines trigger sanctions. Fifth, you need to understand the halftime submission at that point, that how it works. Sixth, understand section 35 inferences risks. When advising defendants about testifying, silence has consequences, or it may have consequences. Seventh, majority verdict rules are examinable. They examine it. Know the timing and voting requirement. At least 2 hours deliberations, then 10-2 or 11-1 majority acceptable. Eighth, remember indictment counts, like, shape the entire case, like, how many indictments. The jury cannot convict on offenses not charged in the indictment. Ninth, agree ROTI transcript to avoid wasted trial time, playing lengthy recordings and all. In exam, you need to keep in mind which deadline is most often missed. Defense statements are commonly late. Know the deadlines and consequences. And I hope this makes sense. If you like this video, hit the subscribe button and share it with your friends. I wish you all the best with your SQE preparation. Ta-da!